Hello friends, in the series on the income tax cases, today we will discuss the case of D&C Phoenix versus Assistant Director of Income Tax. This case has been reported in 104 ITR Tribunal, short notes 55, and the matter has been decided by Ahmedabad ITAT D bench. The date of the judgment is 26th May 2023. This case is regarding section 246A, which talks about the appealable orders before the CIT appeal. In this case, for the financial year ending 2018, the assessee entered into an agreement to sell his property, on which the assessee received advance and the purchaser deducted the TDS of the assessee. But in the financial year 2018, the conveyance deed was not executed. So, while filing the return for the financial year ending 31st March 2018, the assessee did not claim the credit of the TDS which was deducted in 2018 on the pretext that the corresponding income has not been shown in 2018, but in the financial year 2019, when the sale deed and when the conveyance deed was completed, the assessee claimed this TDS, which assessee has shown in 2018 as carry forward. The simple rule of claiming TDS is that you have to claim the TDS in the year in which you are showing its corresponding income. So the assessee was correct in his approach by not claiming the TDS in 2018 because the sale deed was not completed in 2018, and in 2019 when the conveyance deed was done, the assessee claimed the TDS. But the CPC did not give the credit of the TDS which was carried forward by the assessee from 2018 and passed the order under section 143 subsection 1. The assessee filed CIT appeal against this order under section 143 subsection 1 for getting the relief that the TDS credit of 2018 should be given to the assessee. The CIT appeal, while passing the order, said that section 246A only allows the appeal against the order passed under section 143 subsection 1 only in a case when there is a variation in the income of the assessee. It was the contention of the CIT appeal that when the TDS credit is not given to the assessee in the order under section 143 subsection 1, that cannot be appealed against the CIT appeal. Meaning thereby that in the present case, in the order under section 143 subsection 1, the income of the assessee was not increased by the CPC or by the assessing officer, but the credit was not given. So it was not affecting the income of the assessee, it was affecting the taxes of the assessee. So according to the CIT appeal, this order is not appealable under section 246A. When the assessee moved against this order to the Honorable ITAT said that the learned CIT appeal has taken a very restrictive view of section 246A. It was the point of the ITAT that whether income is increased or not, and even if the order passed under section 143 subsection 1 has the effect on the tax determination of the assessee, in those cases also the assessee can file appeal against the order under section 143 subsection 1, meaning thereby that if the credit of TDS has not been given to the assessee in the order passed under section 143 subsection 1, even those orders can only in that case those orders are also appealable under section 246A before the CIT appeal. Friends, this case is very important because this is now a journal problem for the assessee that the credit for TDS is not given to the assessee. So This case will help all those assessees for filing the appeal before the CIT appeal against the orders in which the TDS credit has not been given by the CPC or by the assessing officer to the assessee. At the end of this video, once again, I am repeating the name of the case. The name of the case is D and C, Phoenix versus Assistant Director of Income Tax. And this case has been reported in 104 ITR Tribunal, short note 55, and the matter has been decided by Ahmedabad ITAT D bench, and the date of the judgment is 26th May 2023. Thank you, friends.